Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain copyrights. Copyrights are, along with patents and trademarks, one of the three key types of intellectual property. A trademark is a way to protect a business's name or slogan or logo. A patent is a way to protect a discovery, an invention, or an idea. And a copyright is a way to protect an original work of authorship. Original works of authorship can be protected whether they are published or unpublished, so you don't actually have to be published in order to be protected. All that's required in order to have a copyright is that your original work of authorship is fixed in a tangible medium. And this doesn't necessarily mean that you need a hard copy of your work, as long as it's visible on a computer or other device that's fixed in a tangible medium. So the upshot is, once you've made your work and put it somewhere that people can view it, whether it's on a computer or printed it out, whether you've published it or not, whether you filed the copyright registration or not, you have a copyright in your work. So the first person to do that has the right to the intellectual property in the original work of authorship that's protected by the copyright. So why should you register for a copyright with the U.S. Copyright Office? There's a couple good reasons to do that. A lot of people think, well, I've already got an automatic copyright, but registration is important. Because if someone actually infringes upon your copyright, you can't file suit against them unless and until your copyright has been registered. So you can't stop them from stealing your ideas or your work until you've registered your copyright. Now, it's true that you can register your copyright after the infringement has occurred, but you generally won't be able to get statutory damages or attorney's fees if you haven't registered before the infringement occurred. So this is important because often copyright damages are really hard to prove, and this makes copyright cases basically not economically feasible unless you're going to get the damages that are required by statute and have the other party pay your attorney's fees. So having your copyright registered makes sure that if someone violates your copyright, you get your attorney's fees covered and you get some damages that make the suit worth pursuing that are required by statute. Finally, if you register your copyright within 5 years of publishing your work, the registration serves as something called prima facie evidence of your right to the work. So just because you've registered your copyright doesn't automatically mean that you're going to win your copyright case. So if I write a book, someone else can register the copyright with my book, and if I can prove that I wrote it, reduced it to a tangible medium first, I can still win the copyright case. If the person who registers wins the case, then they get the statutory damages and attorney's fees. But if someone else registers a copyright I made, their registration is prima facie evidence that it's their work. So it's a huge burden if someone else registers a work that I made, a huge burden of proof that I have to overcome to show that, no, in fact, I was the one that made this work first, even though they registered first. So, again, the reasons to register a copyright are basically making it economically feasible to file a suit. You can't even file a suit until the copyright is registered. And then making it easier to win the suit if there is a lawsuit and someone infringes your copyright because of the prima facie evidence that you own the copyright in the work. So let's talk about how to register a copyright. So copyrights are registered with the U.S. Copyright Office. And in order to do so, you file an application, a copy of the work, and a fee for registration. It's not a terribly complicated process, but there's a lot of T's to cross and I's to dot, so it's helpful to work with an attorney. The copyright process is encouraged to be done online. It happens quicker if it's done online, and I think there may be a reduced fee. But even if you file the application online, you still have to file a hard copy of the work with the U.S. Copyright Office. The process takes about 8 months if you do it online. It takes up to 14 months if you don't do it online, if you do it through paper. But it can take longer or shorter depending on how busy the Copyright Office is at the time. But don't worry, your copyright registration is effective on the date that your application was properly submitted, not as of the date that the copyright is approved. This is why it's really important to work with an attorney when filing your copyright application, because you want to make sure that you get it right, because if you improperly submit it, if there's anything wrong with your form, the Copyright Office will reject your copyright registration and you'll have to start over a year or so after the initial application, and you won't have protected your copyright during that period. If it's done right, even if it takes a year for them to approve it, you're protected from the time that it was properly submitted. So let's talk about the poor man's copyright. So there's a mistaken notion that sending a copy of your work to yourself through the mail has the same benefits as registering a copyright. There's a myth doing that is not effective. There's no such thing as the poor man's copyright. You actually have to register the copyright in order to get the benefits that we talked about of the registration. So thanks so much for listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.